I've never done a will before. Do you have any tips for how to get started? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And today we're going to look at 5 quick tips if it's your first time creating a will. So if it's your first time creating a will, I'm here to tell you that it doesn't have to be an intimidating process. It doesn't have to take you a year and a half to draft some long 95-page document that is so complex that you don't understand half of the terms that are out there in the document. Instead, we want to create a straightforward document that you understand so you know what your legacy entails, where your assets are going to go, how things will be distributed, and you want to know that your family is going to be taken care of after you're gone. These are the important goals we have, and so a lot of times when people come to my office for the first time, having never done a will before, they're a little bit intimidated. They're not really sure what's going to happen next. I think they're expecting a big ivory tower lawyer with a fancy suit on, and they're going to get a huge hourly bill month after month as they work on this estate plan with these long documents, and they don't understand half the words, but they've paid so much money that what else are they going to do but sign it? It doesn't have to be that way. It can actually be a straightforward process where we make sure we take care of what you want your legacy to look like as part of your will. So let's look at these 5 tips I have for you. Number 1, a bequest to your spouse. So if you're married, we want to think about what are we going to leave to our spouse as part of our will. Now for most people, this is one of the easiest things to answer, and that is whatever I have goes to my wife or my husband at the time of my death. That's a very common provision. It's nothing that takes a lot of time to think about. However, if you were married before, if you have an ex-spouse and you have children from a prior marriage, maybe you still owe alimony or you owe child support, in those cases we may have to have a little more in-depth dive into what your estate plan looks like and whether we have to leave money for that prior spouse or those children from a prior marriage. Number 2, what about your kids? Are we leaving a specific bequest to your children? So normally your inheritance will be left first to your spouse, and then if your spouse is dead, to your children. It's again a very common situation, but you may also have specific things you want to leave for your children. Maybe you have a classic sports car that your son has always loved. Maybe you have artwork on your walls that your daughter has been admiring for years, and you want to make sure that she gets it when it needs to be distributed. These are what we call specific bequests, and we can use them to make sure that your legacy is left to your family and the people that you are choosing are getting the assets distributed to them when you're gone. Tip number 3, your personal representative or your executor. So this is a term that's used in different states, a personal representative or an executor, and this person's role is to distribute your assets and essentially do what it says they have to do in your will. So your will is going to lay out a plan for what happens to your assets. If you have children under 18, the will is going to specify a guardian for them. It's going to specify a trustee to manage money for them. All of these things need somebody to act as the captain, the person to make sure the ship is going in the right direction and get those things distributed, and that's the role of that personal representative or the executor, depending upon what state you're in. So this is not a role you want to choose lightly. If you have a family member who is terrible with paperwork, doesn't like to deal with courts, just gets overwhelmed by all this, they may not be the best person to choose as your personal representative. However, if you have a family member who's a lawyer, that can be a very good choice for you. If they're a lawyer who's used to dealing with the courts, they could then be the one who handles the personal representative and the executor duties, and you can also choose whether or not your personal representative is entitled to compensation for the work they do, because if you have more assets, if you have more work to do, it can be a very time-consuming process. And the point of this role is that they're the person who's going to have to take your original will and go to your probate court, be appointed as your personal representative, and then be the one to go through these motions and get everything distributed. And if you don't have a will, then what you're doing is you're leaving it up to the court to decide who the court thinks should be your personal representative. And again, if you have only one sibling and they're not good with money and they're not good with paperwork, they might get appointed by the court anyway. You've left a big headache for your sibling. Tip number 4, let's consider whether you want a will or a trust. So a will and a trust are 2 different ways to manage your assets after you're gone. The will is a document that only takes effect once you're dead, and it will distribute your assets. The will has the guardianship of your children and can appoint a trustee for them. A trust can be a living document that actually you can put into place now while you're still alive. You can transfer assets into the trust. You can have a trustee as part of the trust manage those assets. So if you're running a business and you want to make sure that business continues after you're gone, you can have a provision in your trust that your trustee will manage it for you. Now, the trust cannot actually designate the guardian for your children. That would have to be in the will, but there are many other provisions that overlap between a will and a trust, and that's going to lead us into point number 5 for this, which is working with an attorney. You're watching a video on a YouTube channel by an attorney, and you had to know that this was going to be one of the tips. So I can give you these simple tips, we can get you started, but at the end of the day, the most important discussion you're going to have is with your spouse and with your attorney, or with your family members and your attorney, to make sure we're crafting that legacy that you're trying to design. The attorney will be there not to tell you what to do with your estate, but rather guide you and say, okay, if you want to do this, if you want to leave that red Corvette to your son, here's how we're going to do it. You want to leave the artwork to your daughter, here's how we do it. Our role is not to reinvent the wheel. Our role is to take you through the process of deciding what you want your legacy to look like, and then we create the documents that will then have that legacy go into effect after you're gone. So hopefully these have been 5 simple tips for you when you're considering your first will, your spouse, think of your children, choose an executor or personal representative, consider a will versus a trust, and then work with an attorney. If you have more questions, you want to talk further, you can go to my website, 𝙃𝙀𝙍𝙀.com. There's a red legal strategy session button on the front page. If you click that, you'll be taken to my personal calendar. We can set up a 15 or 20-minute legal strategy session to discuss where you are in the process and get those questions answered about your will. If you like this video, you can hit the like or the thumbs up button below. You can hop on over to YouTube or ayerslaw.tv.com and subscribe for future episodes. So if it's your first time doing a will, these are 5 simple steps. It doesn't have to be intimidating, but it's a very important part of the process. You want to make sure you understand your will so you can craft the legacy that you desire.